Okay. I don't want to spend too much time on introductions, but I think introductions are important. You may not know who I am or who Electra is. I have spent 15 years in this intersection of contract technology, legal tech, and software. And then I, had a short stint as an in-house attorney where I was living through these problems. But the majority of my career has been in building software solutions for in-house attorneys, for HR teams, for business teams that help them make their lives better and work faster. I'm also the co-founder of Law Insider, which I started 15 plus years ago when I was in law school. And now many of you may have come through Law Insider. So I wanted to bring that to the table. I have launched a software tool called Simple Docs, along with a great team of engineers. We won't be talking about Simple Docs today, but it is the lens through which I think about contract automation, because we're in the business of identifying routine contracts and helping organizations accelerate those so that you can get back to work to focus on more important things. Electra's background is better than mine. And Electra, I'd love to turn this to you for a moment to tell us about yourself and the context through which you come to this presentation today.
Thanks, Preston, although definitely not better than yours. I founded TLB, which is a legal optimization company, and we work with in-house counsel who have an operations problem, and we effectively help them use technology and better process design to streamline the way they operate. And I'm also the co-founder of an initiative called One NDA. For those of you who haven't heard of this initiative, it's one that goes to the heart of effectively automating and streamlining and even eliminating the negotiation and the time we spend around routine contracts, specifically the NDA. So thanks for having me today, Preston. For those, as I said, that don't know about One NDA, I just want to spend a couple of minutes talking to you about it. One NDA started off during COVID. What happened during COVID is that TLB, as a legal optimization company, working with its clients, realized that they were less interested in streamlining their operations and much more interested in getting people on board to help them with their routine contracts because they just had too many of them. And as a young company that we were at the time, we turned our hand to that and we slightly pivoted during COVID to offer more of a managed service. For those companies that had too many contracts to review, and had hiring freezes effectively. So we stepped in and we helped them with their contracts, and our company grew hugely during COVID on that basis. When I say hugely, we quadrupled as an organization. And then at the end of that first year of COVID, we did a deep dive into the types of contracts we were reviewing for our clients. And remember that at the heart of TLB is the desire to help optimize the way that legal teams work and definitely not perpetuate problems that are there. And we found that 63% of all agreements that we'd reviewed were NDAs, but that only accounted for 7% of our revenue. So it was very clear that we were, in fact, perpetuating the NDA problem, which was systemic, and it was an industry problem. And we decided that that didn't sit well with us and that we needed to do something about it. So I've been thinking about this a lot, and I come from the space industry initially, and in the space industry, because it's just heavily regulated and it's very nuanced. The European Space Agency, which is the organization that I worked for, has issued standard contracts, and the whole of the industry has adopted these contracts. And it's very easy to enter into negotiation with a partner because you're working off the same standard. And I always had this idea of standardizing agreements that are not just on the verticals, the space industry, the finance industry, but on the horizontal, because an NDA applies to all industries and all types of lawyers use them. So I put a thought out on LinkedIn and I said, what if we all just agreed to one NDA template? What if we all just signed up to the same standard? And I did put this up as a bit of a whim, having seen those horrendous stats from TLB's experience that year. But it had an incredible impact. And I was getting messages from across the world from people saying, I really love this idea, or I had this idea 20 years ago. I can't believe it's not happened yet. And if you spearhead this, we will support you. So I thought, okay, then I'm going to set up a website over a weekend. So I did that. And then I invited people to sign up. And if I said that if I can get 100 people to sign up to say that they will support the initiative, I will spearhead it. And in fact, we got that number. We hit that number 12 hours from launch. So it was clear that I now had to spearhead the initiative, and so one NDA was born.
Well, and I think what you will see today, it's an incredible story, and you can go to onenda.org to read more about it, but it's going to influence the lens through which Electra talks about automation, because so much of automation starts with the template, and we are agnostic. So if you want to draft your own templates or you want to use standards that are out there in the world, what we're going to be talking about today is universally applicable in that sense. But it's really important to me that you all understand Electra's story as it relates to one NDA, and the driver behind it, because a lot of her point of view, which I am very much aligned with, is that a poorly structured or under optimized template simply cannot be automated, or at least not at the scale that is worth effort. And so we're going to be talking about that today. We'll talk about balanced drafting is the foundation of automation. We'll talk about making the case for and against standardization. So Electra and I have some strong opinions about when standardization doesn't work and you should be drafting your own balanced agreement. Electra shared with us that her experience at TLB has brought her into lots of in-house teams, and she has lots of battle scars from helping organizations optimize their process. And so she's going to be sharing some successes and some failures, and some things that she has learned that you can bring into your organization as you go forward to enable your automations. I'm going to be talking about a contract automation framework. This is a device that you can take from us to help measure and assess and plan. It's not just an audit tool. It is a framework for implementing a process and a system of automation, but it also is a mechanism to check yourself. How are we doing? We'll talk about enabling the business, because so much of this, we talk to lawyers all the time who are not used to either buying software or implementing workflows, but they're used to being the recipients of those workflows from the sales team or from finance or other. And when we talk about contract automation, it's typically the legal team that needs to own that. But having a relationship with the business is super important. We're going to be talking about ways to accelerate that adoption. And then we'll talk about measuring success, and sort of how you can validate 6 months from now, 12 months from now, how you are doing on this continuum of automation. There's no perfect automation. There's no sort of scenario where you are, everything is just flowing and you are not working at all. But we'll talk about ways to sort of measure where you are. And then we're going to do a case study at the end, where I'm actually going to do a live demo of showing you what it looks like to automate a specific workflow in a really effective way. And these are automations and workflows that you can use, that you could bring into your own tools or you can build yourself. So that is the plan for today. We're 15 minutes in. We're going to breeze through this in 45 minutes. Electra is going to kick us off. Electra, I want to start with two stats. There's two slides here that relate to how lawyers spend their time in-house. And so if you could take a minute here, because I think it sets the table or sets the stage for the impetus for this entire webinar, because in law school we all learn to just grind it out and work harder and spend more hours, but that is not the mentality we need as in-house attorneys. So tell us a little bit about what it means to take your time back.
Yeah, that's completely right, Preston. And as a lawyer, you're trained to sell your time and to measure your success through your productivity. And so when someone asks you to do something, when you move into an in-house environment, your inclination is to say yes. And that person might be the sales team, another business stakeholder. If they ask you to review a contract and do it quickly, you will say yes, because that's how you're trained and that's how you're rewarded when you're training to be a lawyer. But the result is that in-house lawyers spend around 65% of their time on low-value, high-volume work. And that really doesn't make sense for you as an in-house lawyer, because your job isn't just to churn routine contracts. Your job is to help drive the business forward and move away from being a legal advisor to being a business enabler that has a really good grasp on the business strategy as a whole. If your business is trying to grow really quickly and all you're doing is churning through NDAs, then you're not really supporting the business to grow, because you're not there to do the stuff that matters. And then if we move on to the next slide, the reality is that legal is chronically under-resourced. There's approximately 1 lawyer to 100 employees in terms of ratio, and that's for the faster-growing, smaller organizations. In many instances, in large organizations, that's even worse. It can be 1 to 200 or 300 employees. So legal teams are a cost center. As you know, as unpopular as that sounds, we are a cost center, and so we are chronically under-resourced, because the business isn't going to fund legal proportionately to its growth ever, because we are a cost center. And on that basis, it's really important to find a way to completely automate as much as possible and create a much more streamlined approach when it comes to your routine contracts, because it is just such a time drain with not much ROI.
So Electra, let's start there. Let's start with the template itself. And we're going to talk about standardization next, but standardization is not a silver bullet. There's lots of routine contracts that should not be standardized. And so this is not an ideological presentation where we're going to say everyone should standardize everything. You need to have good templates, and you should draft those, or you should have your outside counsel draft those. But help us kick this off, or let's start this, Electra, through the lens of balance drafting and what that means in particular. Balance drafting generally sounds great, but what does it mean in particular for routine contracts? Why is it so important?
Yeah, so lots of companies will have their own templates, some don't, but those that do, it's often tempting to create a template or to accept a template that's been drafted for you by a law firm that's very one-sided. And the problem with that is that when you put your one-sided contract over to the other side, you're inviting red lines, and red lines will cause delays. And so if your organization's objective is to grow and you're causing delays because you've got a one-sided confidentiality clause in your agreement, which you absolutely know is going to be redlined when you send it over, you are delaying the company from being able to make money. So let that sink in, because it's not just about protecting the business and giving it the best possible position from a legal perspective. You're there to get the ball rolling in the most acceptable way to the business. And your job is to understand the risk appetite that the business has, and not for you to apply your own risk appetite to the deals or to the way that you work. So that's why it's really important to think about speed to contract and how you can facilitate that by taking a more balanced approach to your contracts. So that's the first thing. The second thing to think about is, how do you feel when you get a template through or a contract through from the other side and it's completely one-sided? Because I can personally sometimes get a bit angry, because firstly, it's disrespectful for you to send me a contract that shows that you've not considered how I'm going to take that. You're now causing work for me. I've got work to do. I'm under-resourced. There's 100 employees to 1 lawyer. I'm spending all my time on routine contracts. Please don't labor me now with work that you could have foreseen. And so when you start a relationship that way, and let's remember that contracts aren't there to eliminate every single risk possible that you can fathom. Contracts are there to facilitate a fruitful relationship between the parties. So you're not really your imbalanced contract is not conducive to that outcome. So just think about that as well. And then finally, by sending a balanced contract, you are basically going into the realm of fewer negotiations. And fewer negotiations are great because you're saving loads of money. You are building relationships. You're building bridges with the other side. It's an opportunity for you to build rapport with the other side by not entering into protracted negotiations with them. And so generally, it's a win-win for all parties. So just think about the risk-reward element and the carrot and stick element of you having imbalanced terms that, yes, are better for your organization in the event of a dispute, but that comes at a cost, and that's at the cost of the speed of contracts and your relationships.
Yeah. And Andy asked a good question, which is, balanced contracts sound great, but what do we do with the Microsofts of the world? And, listen, today, the title of the webinar is your routine business contracts. And, last I checked, Microsoft was not on this webinar. And I think that they have the level of leverage that allows them to be a little bit despondent, a little bit arrogant as it relates to this. But that's not always the case. There's a great company that Electra and I know, and what they do is they check how balanced commercial agreements are by Fortune 500 companies. And it's really interesting because you can see, because they call out the organizations like Microsoft that are so incredibly one-sided. So listen, this framework, this method of thinking that Electra is sharing with you, may not be adopted by all. And that's a whole other set of criteria in terms of how we receive and negotiate or try to negotiate. I remember as a law student, one of the first lessons I learned when I went to my first conference was that Microsoft is different. So I appreciate the comment there, Bill. Okay, let's jump to standardization. Again, standardization, if folks here are against it, that's wonderful. I think it's a good thing to understand when it is valuable and when it is not. But Electra created one NDA, so she believes in it. I believe in it. And I think in particular for the NDA and a few other agreement types, relying on a standard can make your life easier in ways that a well-written template cannot. So even if you're like, I think my template is better than one NDA, Electra and I will be sure, okay, you won, it's better. But there are attributes to adopting a standard that streamline the process. So Electra, let's jump into it. What makes a contract right for standardization? Let's start there.
Yeah. So routine contracts that are high in volume and that basically say the same thing but in different words are completely ripe for standardization. So let's take the NDA as an example. Most NDAs do say the same thing but in different words. And if they don't say the same thing, then they should, because if you're putting things in there that are completely over the top, like penalties, financial penalties and stuff like that, the other side is just going to see that and go, do you know what, that's not market standard, I'm going to delete that, this is just an NDA. I just want to have a conversation with you about us potentially entering into a business transaction. I'm not going to open myself up to that. So there's no reason for which we wouldn't all agree to a standard set of wording that will eliminate lengthy negotiations and remove that battle of the forms that we have at the beginning of the conversation of whose NDA, yours or mine. So that all takes up time. And the standardization works, and there are examples that demonstrate that. So the ISDA is a great example. The construction industry, particularly in the UK, is totally standardized. I love the way that industry works. Then you've got the European data protection standard model clauses that also work. So we have examples in laws of where standards work. But as I said earlier, they're all in verticals. So the ISDA, people are incentivized to pay an organization to go, here's a standard, guys, because you're spending millions on law firm fees. But there are no standards, or there are very few standards that go to the horizontal that apply to all industries. When you've got things like NDAs, it absolutely makes sense.
Yeah, and one sort of point that I will challenge on, and I think it's a really good question, is what is the incentive of a standard, or what is the incentive to adopt a standard? And I want to use incentive in the most cynical way possible. And, we went to law school to issue spot and to learn to process complex sums of information very quickly and make arguments on behalf of our clients. And the notion of standardization is very much like a dismissal of that notion of saying, I know that's how I'm wired and how I was trained, but not for this. And what I love about the NDA, I think the order form is this way. I think maybe some cloud service agreements are this way, is that there's a growing percentage of lawyers that say, but not there. I'm not going to apply my intellect there because these are never litigated, because yes, I would word this differently, but my wording versus their wording, it shakes out in the wash is the same. So let's not belabor this process. Let's not do this tedious work. But both parties have to feel that way. And I think that there's the majority of contracts, even unfortunately routine business contracts, they don't fall into that bucket. I think we still as lawyers are guilty, perhaps rightfully so, of needing to get our hands dirty, of needing to pull out the red pen, because that's what we're trained to do. And in many ways, that's our job. And so what we're looking for when we say standardization is these use cases or scenarios where both sides are more likely to say, this is not where we should be spending our time. So in any event, I think the goal of standardization can both be to eliminate red lines or reduce red lines. I think things like ISDA and other examples that Electra mentioned, those are about reduction, because negotiations are still taking place, but in the margin rather than at the core. And so it's interesting to think about what it means to adopt a standard. And Electra, I don't know if you have sort of examples in your mind of where specific standardization does not work or where we're in elimination mode rather than in reduction mode. But I know that is an example of how one NDA is drafted, that you can't edit it. If you edit one NDA, you've departed from the standard. So it's very, very rigid in its application, which means it's more of an elimination model rather than a reduction model.
Yeah, that's right, Preston. And if you look at what the European Data Protection Board has done with its SCCs, its standard clauses, it's done the same. It said, you guys are not negotiating this. You can just take this form and sign it because these are the standards that we need you to abide by. And people just do it. And although they're lengthy and horrible, people love them because they're not negotiated. And that's what we did with one NDA. We took a very rigid approach. And I think that approach is only suitable for certain types of agreements. A very small number of agreements, actually. So the NDA is one of them. The DP is another, because they do all say the same thing, but with different words. And the ones that don't are for the more nuanced scenarios where you do actually need a lawyer that's trained to have a conversation and a negotiation to make sure that things are aligned for both parties. So yeah, I agree that both we can both eliminate and reduce, and those can be different objectives. But when it comes to the contracts that we really shouldn't be negotiating because we've got better things to do, we should be trying to eliminate as much as possible.
Yeah, that's great. Tyler, I saw your comment. We will follow up. I'll put it in the package of resources we send out after, examples of standards. There's lots of them out there. Tyler specifically is asking about construction contract standardization. So Tyler, we'll send you a list as well as non-contract standards as well. Okay, automation failures versus successes. This section, Electra, I'm looking at the time. We're about halfway through. Let's see if we can get through each of these in maybe 4 or 5 minutes. But I think that I want everyone to really appreciate the vantage point that Electra is bringing to this. She's not just a really smart lawyer that is exceptionally good at reviewing contracts. For a living, for many, many years, she has gone into legal departments that are understaffed, that are under-resourced, and help them design systems of automation. And sometimes those systems are incredibly well adopted, and sometimes they fail. They fail not because of how they're sketched on the whiteboard, but they fail for very practical reasons relating to the politics of the organization or other impediments that make system design and automation virtually impossible. So I think she is coming with a load of experience, years of experience doing this. And so I want everyone to take a close look as we go into this. For fun, let's start with the failures. Electra, why don't you run us through this and then we'll jump to the successes after.
Sure. Yeah. So just for context, the most common type of client that I work for is an in-house team, legal team that's looking to automate the way they work because they understand that they need to be doing more with less. And they want to usually deploy technology to do this. And the use case that I always advise they start from is automate your NDA, because it's the most ubiquitous type of agreement that you've got there and the one that you really don't want to spend your time on. So the first reason why lots of teams fail in this kind of legal ops transformation journey that they want to go on is that they have unrealistic expectations about what they can achieve. And what they think they're going to do is buy a piece of kit like CLM or a document automation tool or even an e-billing tool, and it's going to be plug and play. They're just switch it on one day and it will work. This is not the case. Anything to do with legal usually touches upon lots of different departments, and so change management is key. Don't underestimate the importance of doing the groundwork, which I'll cover in the rest of these grim bullet points here that we've put. So the second is poor planning. Any change, particularly in the way that your team or business stakeholders engage with a legal document, needs to be planned. So don't just dive in. Take time to think about how the automation will impact your business and what steps you need to take. And make sure that the steps that you need to take and the plan that you're putting together is actionable. Because if, for example, your objective is to get the business to self-serve when it comes to sending NDAs to the other side, then you need to think about the steps that they need to take and really put yourself in their shoes so that you can put a plan together that applies to both them and you and your vendor. The third is bad contracts. So people will just take their existing contract. They won't really think about the template and whether it's right for automation. And they will just say, please go and codify this for me. And the first thing I usually say is you need to revamp this contract because it's very difficult for this to work. And things like structure of the document are really important. So you want to be putting all the variables at the top. So anything that you want to negotiate and need to negotiate needs to go to the top. And you're creating almost like a psychological divide here. These are the things that we will accept negotiation on, but these are the things that we don't really want you to touch. And this is serving both you from an automation perspective, but also a negotiation perspective when that document lands in the other person's hands and on the other side. And make sure that your contracts also are written in English that people can understand, or whatever language you're working in a language that people understand. Because if you're expecting the business to self-serve, it's not fair for you to give them something that they really don't understand because it's full of legalese. So try and simplify the language as much as possible as well. The fourth is no buy-in. So take the time at the beginning before you deploy any technology to think about which stakeholders within your organization are going to be impacted by this change that you want to introduce, and make sure that you've got buy-in at the right level. So if, for example, you're implementing CLM and you know that the finance team is going to benefit from this because now you're never going to miss a renewal again, then make sure that you're selling that benefit to the finance team so that you can get your buy-in. So do a stakeholder mapping exercise and then think about that person, both from a personal perspective, if you know them, that's great, what makes them tick, and from a professional perspective, what is it that they want in their role and what is it that they fear, and then put your business case to them to make sure that you have buy-in at the right level. The fifth is a lack of understanding of requirements. It's really easy in a world where there's so much technology, particularly in our space, to just go and buy the shiniest tool out there. But it's really important that you understand your requirements and that you've mapped those out so that you can buy the right tool for your needs. Otherwise, you're getting yourself in a situation where that won't be the case. And they will sell
you everything. So
yeah.
They have every incentive to give you the whole kitchen sink, and that's probably not what you need.
No, exactly. You might just need a point solution for a very simple thing, and instead you're buying a huge piece of kit that's going to take you years to implement. The next is overlooking process complexity. So it's really easy to just think, I have this process, I am now going to digitize this process. But actually, what you need to do is simplify that process as much as possible. So start by looking at all the processes that you want to automate, mapping those out and optimizing them before you then go into the next stage, which is to automate them. Related to all of this is just buying the wrong tech. So some people buy a huge system to do one job or try to shoehorn a system that's not fit for purpose to make it work. And that doesn't mean the tech is bad. It just means that it wasn't suitable for your needs, which is why it's so important for you to do proper mapping exercise to understand your requirements, who you need to influence, and what your processes are that you need to automate, and simplifying those as much as possible. The next is insufficient resources. So often people don't really understand what budget they're going to need. Don't just think about the tech that you need to buy and the licenses that you need to pay for. Think about the people that you're going to need to run the tool, the people that you're going to need to help you implement the tool. You might need to hire a project manager. Think about your budget, think about any other constraints that you might have, and make sure that you have enough resource to plug those. Otherwise, it's going to be really difficult for you. And remember, you're also really busy, so it doesn't make sense for you to be paying for licenses that you're not using, and then you've got your CFO going, where's the ROI here? You don't want to put yourself in that position either, because that's also not good for your change management objectives. And then we have going too big too soon. Now, this is really common. I see this a lot. People want to buy a piece of kit and they just want to implement it across the board immediately. That really doesn't work. You want to think about, what's your minimum viable product? What's your POC? How can I get something to work really quickly, see the ROI, and then use that as leverage to influence more people? Remember, this is a change journey. It's not just here's a piece of kit, go. And then finally, thinking it's one and done, failing to gather and incorporate feedback on an ongoing basis to improve the way your system works is really problematic. So you want to make sure that once you've implemented a tool and you've rolled it out, you've got processes in place to gather feedback and make sure that you're constantly iterating and making it better.
It gives me anxiety having you walk through this list, Electra. I think that the one word, if I were to summarize this, you may disagree, or one phrase is, please start small. Because when Electra says buy-in and budget and it's not one and done, these are things that if you pull back are very anxiety inducing, especially for a part of the business. And I'm not projecting on this anyone. Some of you may be very skilled at buying and implementing software, but presumably most of you are not, because in our roles as in-house attorneys, as legal ops professionals, we're not doing it that often. Starting small reduces the need to accomplish all of these other things, the multiple stakeholders, and start small. That's all I would say. Even saying it reduces my anxiety. So that was wonderful, Alexa. Let's talk about the flip side. Let's talk about success.
Yeah. So I think that the first thing that you need to do is just keep it real. Just be really clear about what it is that you're doing, what problem you're solving, and be really honest with yourself about why you're going on this journey. It can be expensive, it can be laborious. So think about what it is that you're doing and why you're doing it, and just focus on that. Thoroughly plan what you're going to do, who you're going to speak to, who you're going to roll it out to first. If you're automating your NDA as your first use case, that's a great one. Think about one team that you can roll this out to, and make sure that that's the right team because they have the right incentives and the right volumes. And then use them as your POC, not just to test that the software works, but also to learn how to do this, and then take those learnings and apply those more broadly as you roll out more of the solution. The third is, take the time to redesign your contracts or adopt a standard that's really good. because that will just save you so much time and money in the longer run. And it will also allow you to get buy-in from people. Law is scary. So getting a salesperson to negotiate an NDA or just even send it to the other side can be quite daunting. So making sure that the NDA is in plain English and it's understandable and it looks good actually goes a long way. Stakeholder buy-in, just to Preston's point, if you start small, this isn't a huge thing, but if you try to roll out a huge system across a massive organization, this is just going to be such a big piece of work. So if you start small, you only need to think about those stakeholders that you're working with for your POC. So make sure that you've got them on board and then use them as advocates, brand ambassadors, if you like, to help you get buy-in more broadly as you roll it out. So think of it in waves. Have very clear understanding of your requirements. So just because a huge CLM also does document automation doesn't mean that you need that big CLM. Think about what you need, why you need it, and whether the time is right now. That huge CLM might be amazing, but it might not be right for you right now. And if you buy it and you start to implement it and realize that it's not fit for purpose, you're then kind of damaging your chances of implementing any change transformation in the future because you're taking people with you on this journey and you just want to make sure that you know what it is that you're doing and why. Process complexity awareness. So this is the flip side of what I talked about earlier. Often you might think that process is quite simple because you've been doing it for so long. Like someone asks me for an NDA, I then go into the file, pull it out, fill it in and send it to the other side through DocuSign. That actually has so many steps to it. So if you map it out, you will really understand the complexity of that process. And make sure that you have that mapped out before you start to implement any technology. Otherwise, it just becomes too difficult and hairy. Appropriate technology selection. So if you have the right requirements understanding and you understand your processes, then you can select the right tool for your needs. Make sure that you're staffed up, you've got enough budget, and that you know what you need. And just make sure that you're doing everything incrementally. Start small and have appetite for continuous improvement because you need to be gathering feedback and speaking to people to make sure that you're updating the way that you work and that the system's rolled out. That just might mean I need to update the training that I created for new staff to make sure that they understand how to use the system. So those are my 10 tips.
Love it. Thank you. Tyler asked a question about ChatGPT. We'll talk about that. I think that there's lots of ways to approach automation, and AI is a way, I think in particular, to help with counterparty paper and the synthesis and the summaries and the alerts and the sort of enabling that process in a faster way than was possible 6 months ago or 12 months ago. But it also comes into play here. So Tyler, you're right. And we have seen it, and there's great examples of it, that we can share with you, where in effect, you're relying on AI tools and ChatGPT powered tools, to trigger fallback provisions, to do things that allow you to both draft and negotiate faster, even with your own paper. Okay. We are 42 minutes after, which means you have 18 minutes to go. I'm going to take a hold of this and go very, very fast. You will get these slides, but let's jump in. We're going to talk about sort of a system approach to automation. Again, I'm wearing a hat as a former in-house attorney, as someone who has led business teams, revenue teams, and is also someone who builds software companies that create automations. And so I have very strong opinions and strong points of view, some of which you may disagree with, but I'm going to show you and share with you how I think about it. First, let's start with the goal. It's scary to think about goals. We meet lawyers all the time in our work at Simple Docs who don't have a lot of conviction here, and you may not have conviction here too, or you may think that my conviction is unrealistic. But the goal is our paper, no red lines, our e-sign. Like, say it out loud, say it with me. Are you always going to get this? Of course not. Will there be red lines? Of course there will. Sometimes will they download it and send it back with their e-sign tool and we can't control it? Sure. But saying that these are the goals helps create a process and a system, and not having goals makes it a little more opaque and ambiguous of what a fully optimized system looks like. The framework, template design, template configuration, template access, counterparty experience, common negotiation, e-sign, and storage. These are the contract automation framework. I don't care if you're using the biggest CLM in the world that Electra will talk you out of buying, or if you're using bubblegum and duct tape to build your own with tools that sales has given you keys to. The same framework applies. Template design, is the goal to reduce negotiations or streamline? We talked about that earlier. What is the purpose of this document? What is our ambition for it? Is it balanced? Is it standard? Is it well structured? These are things Electra already talked about, but we have to start there. Template configuration. Now, how are you going to make it so you can hard code your defaults, the parts of the agreement that you do not want to be edited? Maybe it's as simple as locking a Word document except for a few fields. Maybe it's as simple as preloading it into DocuSign and you being in the middle of the process, although that doesn't sound very fast to me. But there are tools out there that I think you may be familiar with that allow you to put the lock on the parts of your template that need to be locked, while also enabling the business teams to generate requests without your involvement, but also without you worrying that they may have changed something that they don't have the authority to change. Template access. This is maybe the most important one. I know for many of you, you may be putting a Word document, a lock template, whatever it may be, on your intranet somewhere. And you may say, oh, this process is okay. I think that there are other problems, because if I also asked you, do you know where these NDAs or order forms or whatever, do you know where they're ending up? Do you have visibility into them? And you're like, well, no, they're going through DocuSign, and I don't know where they end up because the salesperson's account. Access is important. There's more than one way to achieve access, but having control over the access is also really important, because you want it to be in a way that you ultimately have visibility into without it pulling you into the work. And you know, that sort of efficiency and control, push and pull is really, really important, and access is where it tends to emerge. Counterparty experience. We don't talk about this enough. Electra, I don't even think we talked about it enough as it relates to one of the biggest reasons to adopt something like one NDA. Is this is a part of the counterparty experience. So you're not just saying to them, hi, John, you've never met us before, but I did a really good job of drafting this template, and I need you to trust me that it's balanced. You know what? John's going to read it anyway, and he's going to decide whether it's balanced or not. And one of the benefits of a standard is that it comes with this halo effect, with this social proof saying, no, I'm not sending you my template. I'm sending you the template. Electra, were you going to make a comment there?
Yeah, I was going to say that the neutrality of a standard like one NDA gives you leverage, which is why we say don't put your logo on it. Just leave it as one NDA, because then that gives you the power to say, this is not me saying this is balanced. This is a community of 1,200 lawyers that drafted it, and then all these other thousands of adopters and downloaders as well. So, yeah.
Yeah. And this is one of these areas where I think a lot of organizations have not come this far yet. I put this comment at the bottom. It says no process versus good process. It's easy to just not do this and to say, we're just going to send a template out, and it's our template and we believe it's balanced, and let's see what happens. But you know, if we're betting what's going to produce the better outcome, let's see what happens. The salesperson's going to send it. Who knows what message they're going to send along with it. The counterparty is going to receive it, and let's hope it works out. Let's hope that they don't like to negotiate NDAs, versus taking a much more intentional position, which is, we've selected the standard. Here's what it does. Here's why you should accept it as it is, and it's not ours. And so having more conviction on that really is important as you think about the counterparty experience. Never mind that what that experience is needs to be easy to use and familiar, and shouldn't require them to create an account or anything of the sort. We're not trying to change their behavior. We're just trying to get them to signature faster. Common negotiations. There's lots of tools that do this, but this is one that's maybe the hardest to conceptualize, that maybe Electra and I have the strongest point of view on, and it's this idea that there are a set of common negotiations in every routine agreement. You know what they are for your agreement because you see them every week. You see them perhaps every day. And is there a mechanism through which these can be dealt with differently than just sort of raw redlining, which is still going to happen. Redlining is going to happen, but can we eliminate and isolate the common negotiations so that those are dealt with differently? Lots of software tools do this, but it's something for you to think about as you're going through this effort of adopting a standard or drafting your own balanced agreement, thinking about the counterparty experience from the lens of negotiation and how we streamline the parts that get negotiated the most often, is a helpful framework that also ties to the design. And so standards, in many cases, like one NDA, have actually been designed to isolate where the common negotiations occur, so that we're not trying to go clause by clause to find the areas, but actually they're put on top. Like, let's go, let's negotiate these because I know you're looking for them, and we have fallbacks for all of them, so let's go, rather than trying to hide it within the body of the agreement. Okay, enabling the business. This is just an incredibly important piece that many of you are familiar with. We work with lots of organizations and lots of in-house teams that tell us that they'll say, Preston, we are a part of the procurement process. We're part of the purchasing process, but we rarely, if ever, purchase software. And when we do purchase software, it's even less likely that that software is going to be pushed down into pushed down into business teams. And it for some of you, you're like, no big deal, Preston. Like, we got this. But for others of you, it is a little bit like, have I gone outside my lane? I am going to tell the sales team that this is now the software that they are going to be adopting to do this thing that they're counting on me to do. It shouldn't be daunting. I'm making it sound dramatic. It should be commonplace. But a way to overcome it, a way for you to feel better about that process, a way for your sales team to be like, oh, great, is to meet them where they are. And whether that's Slack or HubSpot or Salesforce or Teams or wherever it may be, it's making it so they can generate requests, so they can track status, inside of tools that they're already using, and that they're not forced to adopt new software. And again, I think at smaller organizations, this may be less important, but I think at big organizations where you have huge business teams and very sensitive VPs of sales that don't want their sales teams getting stuck in other third-party platforms, this is a way that you can meet the business where it is, and it makes the idea of streamlining the process less daunting and less scary, because you're saying, listen, this is a software tool that makes my life easier, but I'm bringing it to you in a tool that you're already using. Okay, measuring the success of your automation. We have 9 minutes to go. I'm going to run through this in 3. We're going to do a case study, and I promise I'll get you out of here in 8.5 minutes. 8 minutes. Okay, 10 questions asked. What's this about? Once you have done this, this is just a check. You're going to get these slides. You'll see this list. Are all routine contracts running through our system and our workflow? This is the question you need to ask yourself. Have we really replaced a process? Or are half running through an automated system and half still coming to me via email, and I'm spending my weekends manually running through them? Is legal oversight required to manage routine contracts, to allow them to be sent out? No, please no. You need to get yourself out of the process. Electra showed the slides at the beginning talking about sort of the need to take your time back. You're under-resourced, you're understaffed. Like, the idea that every routine agreement has to pass through you, we need to get past it. Are all signed contracts ending up back in a central repository? Why go through all this work? Why, jump through the hoops of getting an NDA if you don't know where it is? So making sure that you have control and visibility into the process such that the end result is searchable and discoverable. Can business teams generate routine contracts from their business tools? We talked about that. Integrations really matter. Do we have streamlined processes for managing negotiation requests to routine contracts? Can we speed that up, or does it have to be word-based? Does it have to be redline based? Are we always signing with our own e-sign tool? I know you're not going to get to always, but is that the position we're taking? Or are we making that the default? The sales understand that? Are we using tools in a way that get us to that place? Are we getting repeat requests from sales for help generating routine contracts? Are we actually changing behavior, or are we just sort of, pushing a tool that is very reluctantly getting used? What percentage of routine contracts are signed on our own paper? This is maybe my favorite one. Is you look at what you're doing today and what you're doing 6 months from now. Not only should the process be getting faster, but you should say, in a measurable way, more of our deals are getting done on our paper rather than counterparty paper, because we're sending them out faster. Sales is moving quicker. The counterparty is seeing that it's more balanced for the reasons Electra and I have been talking about today. Our new employees easily adopting the process. You don't want to be the trainer, right? You want this to be easy. You want it to be intuitive. You want it to meet the sales team where they are. So I'll send you this list, but these are good questions to ask yourself at various stages of your implementation, as you're thinking about routine contracts. Okay.